Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
All right, welcome to another episode of Empowering Plans. Today, you've got myself, Kevin Brady, and Andrew Silverio. Say hello, Andrew.
Hello, everybody.
And today, we were looking at this article, and it's something that's come up. I've seen it actually across a lot of different medical news stuff. I've seen it on CNN Business. I've seen it come up quite a bit. And it has to do with brand new kind of sensation going on across America right now, and it's pickleball. Do you play pickleball, Andrew?
No, actually, I'm an avid tennis player, so I have sort of a personal vendetta against pickleball. They're quite literally encroaching on our territory, but I'm very familiar. I see them all the time.
Yeah, and I think the argument is that pickleball is a lot easier than tennis, right? So it's a lot more accessible for people.
Yeah, less demanding on the body. It's popular with older folks, and it takes up less space.
Yeah, that makes sense. Well, this article that I'm reading now and kind of some of the other ones I've seen would argue that maybe it isn't as easy on the body as some people might think, because it's driving up unexpected medical costs quite a bit. So, for example, one of these articles that I'm reading here says it could go up to almost $400 million in healthcare costs that are directly attributable to pickleball injuries. Now, I don't know if that's hips or knees or wrists or maybe just general health issues, but that seems like a lot of money. I don't know. What do you think?
Yeah, for sure. I think a lot of it is, older folks who are getting out to, get exercise and see pickleball as a safer way to do that. Maybe some of them aren't quite ready to be, running around on a big pavement slate.
Right. Yeah. Well, I mean, I've played pickleball a couple times now myself. I mean, I'm not like a regular by any means, but I've played it a couple times, and I will say I'm not good at tennis. Getting out on the pickleball court, I feel pretty good. Like, I feel like I could, make some noise in the pickleball game. But that's just pretty anecdotal, considering that my competition wasn't really that good anyway. So, but I'm sure if you picked up a pickleball paddle, if you're like an avid tennis player, you'd probably be pretty good. Would you agree with that?
Maybe. Who knows?
Maybe.
We'll find out when in a couple decades when I can't play tennis anymore.
Right. Yeah. Kind of put you on the spot there. Didn't want you to be modest. But anyway, so yeah, we could talk pickleball all day, or I could at least. And it sounds like you could probably talk tennis all day. I could talk pickleball all day. But I think really what would be interesting here is to kind of take this pickleball conversation, thinking of the unexpected medical costs, right? And then thinking of how a plan may or may not want to exclude such expenses, right? Like, not necessarily just talking about pickleball and injuries from pickleball. Like, I don't think anybody in there is going to have a pickleball exclusion. I mean, maybe it's not the craziest thing in the world. It also seems like it might be a little targeted, right? But in general, I wanted to talk about just general limitations, exclusions, kind of get your take on some of the things that you've seen in the industry. And maybe what we can do is just do a back and forth, like a little draft, and we'll pick our favorite exclusions. Maybe we both pick 3 of our favorite exclusions that we've seen, whether it's interesting or super effective or super important for a self-funded plan. And then maybe we can also just talk about one each that we're a little iffy on, that we've got our own opinions on. You want to do that? Does that sound fun?
Yeah, sounds fun. Let's do it.
All right. So with just me being the gentleman that I am, I'm going to allow you to go first. So you can go first, pick any exclusion you want. If you say it, I can't use it as my own. And then same goes the other way. If I say one, you got to pick a different one. So we're going to end up with 6 exclusions that we like at the end of this, and then 2 exclusions that, not saying we don't like necessarily, but there's some nuance we need to talk about a little bit more. So with that, I'll turn over to you to go first, and I'm excited to see what you got.
Sure. Yeah, well, I'm going to kick it off with a classic, one of the originals, medical necessity. It's not exciting. It's not
great
sexy,
pick.
But yeah, it's super important. Also beyond just the way we traditionally think of medical necessity exclusions, it casts a really wide net that catches a lot of the different issues that we've been hearing a lot about. Like earlier today, you were talking to me about an expensive new gene therapy drug, right? I'm not sure if we were recording yet, but $2.5 million a year or something like that for an adult. So good medical necessity language can pull in things like, unproven new drugs, stuff like gene therapies that maybe are under like a experimental approval, not fully FDA approved or not widely accepted in the medical community yet, to give sort of a first line of defense to a plan that hasn't looked at something like a broader, gene therapy exclusion or a vendor program or something like that. It can catch, drugs coming from abroad if you don't want to allow importation. Your medical necessity language can include language about FDA approval, that sort of thing. There's all sorts of unexpected, cost protections that can come from good medical necessity language and good medical management practices.
Yeah, that's a dynamite 1-1 pick. I think anybody listening, if they're trying to think, what's going to be the first pick here, I don't know if many people are actually that thought process going through their head, but I feel like medical necessity is got to be up there number one. Great 1-1 pick, way to kick things off. Super good, super important. So
LeBron James of exclusions.
Yeah, exactly. Maybe some would argue maybe than Michael Jordan.
It's a different conversation.
That's a different conversation. Yeah, that's a different snake draft that we're going to have to do at some other point, maybe on a different podcast.
Only Chris Aguiar to talk about Michael Jordan.
Right. Yep. All right. So I'll go next. And medical necessity is really, really good. I probably would have taken that 1-1. I think I'm going to pick one here that maybe I'd be able to get later in the draft, but I just like it and I want to talk about it, is hazardous acts. And the reason I like hazardous acts is because it's just so interesting. It just opens up this realm of what would be considered a hazardous act, right? And when I look at the exclusions, so if I'm looking through our plan document template and I get to this one, I'm always I always take a second, I'm just reading hang gliding, skydiving, bungee jumping, parasailing, all these things that are, I feel like they're just popular amongst a certain, group of people. And it just leads me to always think about for self-funding purposes, right? You want to look at your risk pool and try to understand who are the participants on the plan here, who are the employees, and think about the risk pool. And then what are these types of activities or things going on? And I just think anytime you have an exclusion like this and you're just reading those buzzwords, it's just it's a little bit exciting. I don't know. And then it just gives a lot of latitude in terms of do you want to include an exhaustive list of things that would be considered in a hazardous act? Do you want to including but not limited to? Or do you want to just leave it to that kind of general statement of hazardous acts in general, and then leave it to the plan administrator's discretion there to kind of determine what would fall into that category? So while this isn't something that would have the day-to-day use like a medical necessity exclusion, which would come up in almost every claim, right? This is always something that I find interesting and kind of just jumps off the page when I'm looking through the document. So that's why I'm going with that as my first round pick.
Okay, good pick. So what do you think about pickleball for hazardous acts?
Yeah, so for me, I would not say this rises to the level of hazardous activities. So basically in our materials, right, we have an optional list that goes in. And if I look at kind of comparing pickleball to speedboat racing or automobile racing or hang gliding, bungee jumping, those kind of things, I don't think it falls into that same category. I actually think there's another exclusion here, which maybe could have something to do with it. Later on, I don't know if it'll get brought up, but I would say that no. But at the same time, I guess, there is broad discretion there, and it definitely depends on how it's worded in the document. What's your thought on that?
Yeah, so I think in that situation, you kind of have to consider your risk pool and your employee base. So maybe for, the average FIA group employee is, I don't know, what do you think, early 30s, something like that? Probably.
Yeah, I'd say.
I'd guess. Probably not a hazardous activity. What if your average employee is 85 and has osteoporosis? Maybe pickleball is a hazardous act. Another example that came up was horseback riding. You have employers in Massachusetts who think horseback riding is a hazardous activity, and an employer in Idaho where half of their employees ride horses to work every day. And they say, what are you talking about? Absolutely not. So you got to consider stuff like that too. So I'd say it depends. Very low-early answer.
Yeah, I know, right? I think, another good example there too is if you're in a rural community, maybe you have a lot of land, right? Horseback riding becomes a lot more common. And then also the use of all-terrain vehicles like ATVs to get around your property. That's a lot more too. But if you're in Boston or Chicago or Cleveland or any of these bigger cities, using an ATV or something like that is a little bit more outside the norm. So it really does depend on both location and then risk pool too. So very, very interesting conversation. All right, so that's my first round pick. And all right, throw it back to you.
So my next pick, I'm gonna go with illegal acts.
Good pick.
Yeah, there's a lot of different exclusions that kind of overlap and touch on the same subject matter. So there's alcohol exclusion, there's illegal drugs. Alcohol, of course, would be more specifically geared towards drunk driving. Our language talks about activities that are made illegal due to the use of alcohol. hard to think of any other than driving, but
Right.
operating other like machinery or something like that. Who knows? Flying a commercial plane.
Yeah.
But yeah, so a well-drafted and broad illegal act exclusion is going to include all of that. It's going to include illegal drugs. It's going to include, DUIs, that sort of thing. And again, it'll cast a wide net. And if it's drafted broadly, but not vaguely, right? There's a big difference. Then it'll be a powerful exclusion. So when I say broadly, but not vaguely, you want to say something like claims incurred as a result of any illegal act, including but not limited to misdemeanors and felonies, right? Sometimes you see exclusions where it looks like the drafter was kind of trying to get too fancy and use words that they just thought sounded legally. So you'll see exclusions that apply only to a felony or something like that. And I don't know if the intent when I see that was to have such a narrow exclusion. But by far, the situation that we see this exclusion come into play most often is drunk driving. And in just about any state, your run-of-the-mill drunk driving offense is not a felony. You don't see a felony charge come into play until you have serious repeat offenses, like 3 or 4 offenses, or some sort of aggravated, like you hurt someone while driving recklessly as well.
Yeah, or like your BAC is like super high. Like there's super drunk laws in certain states, stuff like that.
Yeah, like you're impaired above 0.08, but then, it's an escalated charge above like 0.24 or something really just out of the ordinary like that. So yeah, that's illegal acts. That's my second pick.
Yeah, I think that's a really good one. I also think that's another one with like, I brought up the hazardous acts thing because there's like those buzzwords. I think illegal acts is like, it's just always interesting to talk through and like those nuances that you talked about too. I think all of that's like super interesting. And the wording is so important. And that's a big one for stop loss gaps too.
Yeah, I mean, as far as wording and stop loss gap, another important thing to look for in that exclusion is that it's clear regarding what type of causal relationship it wants to have between the illegal act and the injury. So if you just say you exclude any claim related to the commission of an illegal act, now you can get into things like driving with an expired registration or something like that, which I don't think is reasonable. I've actually seen fact patterns where someone was driving, had some sort of medical emergency, like a cardiac arrest while they were driving, and ended up being in a wreck. The plan wanted to exclude based on illegal acts because their registration or their license was expired. So if your language is clear that it's triggered when the claim or accident is caused by the illegal act, then you can get more reasonable application and also less ambiguity about, when it does and doesn't apply, which is always good for stop loss.
Right. Yeah, 100%. And I don't want to spend necessarily too much time talking about each of these, but another thing too, like I know it's not the exclusion we're talking about necessarily, but it falls into it, is like the alcohol exclusion, right? So like there are a couple different ways, not necessarily drunk driving or anything, but like if you had an open container, if you're in a car where someone else has an open container or something like that, but you're driving and you incur some type of expense, right? Like it's not necessarily related to that specific expense or anything, right? So anyway, I just think it's an interesting kind of topic there, but you're totally right on the causal connection and everything. All right, so I'm gonna go here, and then I think maybe what we do is maybe we speed this up because we are having a little bit more of a robust discussion than I would have thought, but that's good, obviously. So maybe we'll just do 2 each, and then we'll do our third that we're a little iffy on. So with that, I'll kind of speed along here, and I'll start with my second round pick here, and I'm gonna go with excess. And what excess is just gonna be basically charges beyond the plan's maximum allowable charge, or basically the plan's limits on payment. So I think it's important, obviously it's a general rule across the board. The plan is going to pay what the plan outlines is the payment. And then anything beyond that's not going to be covered by the plan. And that's something that is going to give a lot of power to the plan itself to limit those charges to the actual maximum allowable charge and not have to pay for claims and expenses that go beyond that. And it really does matter what that maximum allowable charge or that reasonable and customary, whatever that term is, and how those provisions are applied in the plan document. So when you have really strong definition of that term, like we do in our document for maximum allowable charge, and there's different kind of ways to apply that, whether it's a negotiated rate or it's a percentage of Medicare on out-of-network claims, whatever it might be, having that strong definition of that term, and then coupled with, an exclusion like this where the plan's not, with its fiduciary responsibilities, it's not allowed to pay beyond what that plan document says it can. This is going to, really protect the plan and protect from just, exposure on those kind of out of whack, huge claims and stuff like that. So any thoughts on that being my second round pick here?
Yeah, I like it. And you touched on an important point there about when an exclusion links back to a definition. Obviously, that definition has to be tight as well. So that applies for my first pick, medical necessity. Your exclusion is only as powerful as your medical necessity definition. That applies here too. If you are applying an exclusion for any charges in excess of fill in the blank term, we use maximum allowable charge, but a lot of plans use usual and customary, reasonable and customary. If that corresponding term is drafted in a way that doesn't provide good cost protection, then your exclusion isn't really going to do you any good. The classic example is the usual and customary defined just as, the normal charge by similar providers in the area. That doesn't really help you very much, right? If you are in a pocket where all the providers in the area are charging 20 times their cost, or,
Exactly.
20 times Medicare rates for bills, that doesn't give you any cost protection at all.
Yeah. No, yeah, you're just defaulting to a super high charge at the end of the day, right? So
yeah, I've also seen usual and customary defined just as, the amount the plan deems payable, right? Just no criteria at all. So, I mean, that's good as far as allowing the plan to just consider whatever it wants, but it's awful when it comes to, stop loss gaps. If you need to defend your pricing on an appeal, if a provider says this pricing is invalid, there's no criteria to point to say, no, I considered this and that like I was supposed to. It's all just completely out there.
Yeah, super important to kind of outline the logic and the parameters of payment kind of in detail. And that's kind of how ours functions. And there's a couple different steps involved too, right? Especially now in like the NSA world, where there's certain claims that the NSA will apply, other claims it wouldn't apply. So there's just different ways to kind of go about adjudicating the claim and then what the proper payment's going to be. So yeah, very, very good. Okay, so you got medical necessity and legal acts. I think those are awesome. Those are pretty good. And then I have hazardous acts and excess. And then now we're both going to shift over and we're going to pick two that we're a little bit iffy on. So you go first and then I'll go next. I'll follow up.
Okay, it's tough. Which one? I've got two that I'm eyeing. Let's go with one that we no longer include in any of our materials. I don't see it all that often, but we used to see it a lot. I still see it pop up once in a while. Self-inflicted injuries. So you see this exclusion. I guess the rationale behind it is sort of similar to hazardous activities, right? The plan doesn't want to take responsible for, the participant's own choice to put themselves in harm's way. This kind of takes that a step further, talking about intentional acts. The issue with this exclusion, first off, just sort of morally, ethically, I don't really get behind the rationale behind excluding, intentional acts of self-harm, just as sort of a moral question. But then legally, you have something called the source of injury rule. It's part of HIPAA and it applies to all exclusions, but you see it written into plan language in exclusions where it's more likely to come into play. So you see it in self-inflicted injury exclusions. You see it in sometimes illegal acts or alcohol exclusions, that sort of thing. It basically says that a plan can't apply an exclusion based on the source of injury or illness if the cause of that injury or illness relates to a medical condition, including mental health conditions. So an example of that rule for, an illegal acts exclusion, you might not be able to apply it to a drunk driving claim if there's a documented history of alcoholism or something like that. In this context, you're talking about intentional acts of self-harm. The medical condition would most likely be some sort of a mental health condition, right? Depression, something along those lines. I'm not a clinician or a psychologist, but it's hard for me to imagine someone committing an intentional act of self-harm that couldn't be linked in some sort of a way to a mental health condition, most likely depression.
Oh, yeah.
It's very difficult. Yeah, in practice, the issue with this exclusion is that it can almost never actually apply. And that, anytime you have an exclusion that is going to be inapplicable for compliance reasons, you have the risk of stop loss gaps. Stop loss is going to look at that exclusion and say, well, it's in the plan. This is what we underwrote. So, your non-compliant language, that's not our problem. This is what we considered in underwriting. So you're going to have to pay it, and then stop loss might not pay it. So that's my pick, because when it's present, it's usually not even applicable. It's just sort of an illusion.
Yep, totally makes sense. I've done this exercise a couple times now where I've tried to come up with a scenario in which this would actually maybe be applicable, where it's not going to violate the source of injury rule. And the only thing that I've been able to come up with, and I would like your feedback on this, and I guess we'll get it live here, is maybe like a TikTok sensation where somebody's doing something like intentionally harmful, but it's to go viral or, something like that, where it's not necessarily linked to like a mental health condition or anything like that. So it's like
almost like for entertainment purposes.
Yeah. So like I put butane on my hand and I light myself on fire and then I get 3rd-degree burns, but I did it because I saw it on TikTok and I thought it was funny and interesting, but they actually did CGI or whatever, And that's like one example I can think of, but obviously that's so narrow.
Yeah, and that sort of crosses into hazardous activities too, right?
Exactly. Yep.
It's hard to imagine a situation even there where the intent is to harm yourself. Really, It just seems like
your intent is to go viral, I guess, right?
The person doing that is just being really stupid, right? You're swallowing Tide Pods or lighting yourself on fire.
That was the one,
funny.
Yeah, exactly. So I totally agree. Yeah, the applicability is so low, but the risk is high on the compliance side, and like trying to find that narrow instance, like the risk is definitely outweighing like the benefit or the reward there. So that's a really good answer. That's good. All right, so self-inflicted is off the board. All right, so for me, my final pick here, I'm going to go with something that we've got in plan documents, and I'm not saying that this shouldn't be in your plan document. I'm not saying you should remove it if you have it or anything like that. I want to caveat that as we start here. I think it has some benefits, and I'm intentionally saying a lot before I actually say the actual exclusion here. It can have benefits, but there are risks associated with it as well, and we'll definitely talk through the nuances there. But the one I'm going with is going to be the not specified as covered or something similar in a different plan document. That's why we have it. So it's not specified as covered. So essentially it's, kind of a blanket exclusion saying if it's not listed out as a benefit under the plan, it is not covered. I think that exclusion, that idea or that principle that if it's not a listed benefit, then it's not a covered benefit. I think that's like generally can be intuited or inferred based on like the design of a plan document, right? So you're basically just stating something that's already kind of out there in the ether that if it's not a benefit, then it's not a covered benefit, right? Anything that's, not listed, does that mean that just because I don't have this exclusion, does that mean that something that's not a medical expense, I can just like charge the plan? You don't need to necessarily have this in place to like limit coverage to the covered benefits. And then it kind of draws this question of like, well, how specific do I need to be, right? So if I say preventive care, do I need to list out everything that falls under the purview of preventive care benefits? If I'm saying surgery, do I need to go deep down and say knee surgery, orthopedic surgery, endoscopic surgery, whatever it is? Like, do I need to go through all these different, granular details in order for it to be covered when I say something like this? So that's kind of one of the risks, is that when you include an exclusion like this, our plan document, for example, our benefits, they're a little bit more generalized. They're not going to be hyper specific on every single thing. And there's just a lot of area where things might fall into a category of benefits rather than specifically being laid out. And then there's the argument at the end of the day that something wouldn't be included. So I think the big one there, or the big potential issue there, would be on the stop loss side, right? And it says it's not specified as covered, and then somebody gets a claim for, let's just say, knee surgery or whatever it might be, and that is not a specific benefit that's outlined, then maybe there's an argument on the stop loss side to say that's not reimbursable. So it does have its use in the fact that you don't want to cover benefits that aren't specified as covered, right? But how granular do you make those details within those benefits, all that kind of stuff. So there's a lot of nuance there, and it can be kind of just, it's a little iffy. So do you have any strong thoughts on it?
I do, yeah. I've seen this exclusion kind of interpreted as, and I'll say by stop loss, because we keep coming back to stop loss, as sort of requiring almost that every service or supply that the plan covers has to be specifically listed in the plan document. And my main complaint with this exclusion is that that's just not really how plan documents are drafted, right? We use categorical language like inpatient care, surgical care, prescription drugs. We don't list every prescription drug or every surgical procedure that a person could incur that would be covered, right? So, you kind of want to have it as sort of a catch-all for unexpected, expenses that pop up that you didn't think to address with an exclusion, but, that you don't want to cover. But the risk is, stop loss gaps, and the fact that, a couple summers ago, I had an ankle surgery called a Brostrom Gold procedure. That's not listed in our plan document, right? It just talks about surgical benefits. So, with that exclusion in place, the risk would be that stop loss comes back and says, your plan document doesn't say anything about this procedure. It doesn't even mention ankle surgery. You talk about inpatient surgical benefits. So we're going to deny this. That's sort of an extreme example. That would be a pretty unreasonable stance to take, but you couldn't really say that they were objectively wrong, right? So the risk is there, and you're going to get situations that fall into more of an area where you can have reasonable disagreement.
100%. Cool. Well, this was a fun exercise. So let me just recap the draft board, if you will. So Andrew, got medical necessity and illegal acts as his favorite exclusions, and he got self-inflicted as his least favorite there. And then for me, I have hazardous acts and excess, and then I have not specified as covered. So I don't think we're going to put out a poll or anything on any of our social media outlets, but if anybody, wants to weigh in on who do they think won, I'm a little bit biased, but I have a strong feeling. Although medical necessity and legal acts are a pretty good one too, if I'm being honest. It's a pretty good team. Yeah, I don't know if I can really compete with that, but for fans out there, if you wanted to vote for Kevin, I wouldn't put it past you, I guess. But anyway, this was a great discussion. Really appreciate it, Andrew, and this was a lot of fun. Any parting words?
Yeah, not really. This was a fun exercise. If anyone out there wants to, shoot us your picks, you think that, someone reached in the draft that missed a sleeper, let us know.
Or like honorable mentions. If anybody has any honorable mentions, let us know. And then we'll be sure to maybe do a follow-up at some point to talk about the things we missed. Well, thanks, everybody, and hope you guys have a great rest of the week.
Thank you.